Court has to, there are several cases pending, right? That's why we need more Supreme Court judges. Discussion must be placed in context.
It would have been very wonderful to see 3 chambers of the Supreme Court sitting at the same time. One in the old Supreme Court upstairs, and then perhaps
you should build a new Supreme Court building for the nation.
Right.
Or the Minister of Finance should.
The panel will be reconstituted. All rise.
Right, so we are moving on. Please stop sending more messages on NAPO and the videos that I was just playing, a couple that you are sharing with me, including how NAPO strongly took on the vice chancellors in a manner that some university dons have been very unhappy with him about the way he communicated. We end that discussion here, but let me conclude that with a message from Dr. Kwame Asante. He says that, for the records, arrogance, insolence, etc., have little or no place in the literature on voter choices. But what really influences voter choices are the economy, infrastructure, development, fight against corruption, unemployment, energy, and education, among others. Let's focus on these and leave Napo's character to be managed by himself and his party. Okay. I get it. Thank you. So, as you may have followed in the course of the week, a letter written by the Chief Justice nominating Justice Efia Sewa Asare-Botwe, Justice Pamela Koranting, Justice Edward Amwakwa-Sante, Justice Eric Che Bafo, and Justice Angelina Mensah Homia for consideration for appointment has attracted a lot of criticism. The NDC, at a press conference, stated, among others, that without any equivocation, they think that the Chief Justice's letter is illegal and has no effect. Her actions have completely turned due process on its head and compromised her independence as the head of the judiciary. You may have heard Godfrey Dame. He's come to say what he's aware of is the request from the CJ, and there is no malice in that. The judiciary is no doubt better placed to provide ample justification for an enhanced Supreme Court, but again, it is worthy to note that the Supreme Court of Ghana is quite unique. We have heard from Kwaku Ansah Asare, a former director of the Ghana School of Law, who is unhappy about the manner the process is being done. We've heard from Arthur Kennedy and also Stephen Kwaku Asare, as in Kwaku Azar, whose major issues include that the process of appointing justices of the Supreme Court is not for the Chief Justice to do, and that by doing so also seeks to influence the process in a manner that is not allowed by law. Professor Dr. Arthur Kennedy, why, in your view, this is so wrong? Because you actually support Kwaku Azar's point.
I do. I crave your indulgence to return to Napo for just a moment. I think that we spent a bit too much time on his character. And I think there were more substantive things that we didn't interrogate.
Yeah, we focused the discussion. All other things everybody else is talking about, and there'll be a lot of conversations about him once he has been appointed. And we want to make progress because we actually wanted to deal with that in the first hour and then reserve the rest of the hours to the other, perhaps, in my view, more important issues.
I hear you, but give me just a minute and I'll address your substantive question to me. I think that the argument about where he comes from and what he can bring to the table from Ashanti region is a little misplaced. And as one of my professors says, in God we trust, all others bring data. I take you to 1950. When Nkrumah ran in Accra against a native of Accra and won big, leading to formation of the CPP government. 2004, when Kufuor soundly beat Atamels, a native of Central Region in Central Region, President Rawlings won the North decisively twice without having a Northerner on his ticket. And even in Ashanti, 79, with Victor Uso on the ticket, the second round, he only managed to get 57% of the votes in Ashanti region. So the idea that putting somebody from Ashanti on the ticket by itself is a guarantor of victory, particularly with Alan in the race, I think it's a little bit of pie in the sky. I will let your audience ponder those things. But now to come to the Chief Justice. A lot of people have talked to me about my interest in the judiciary and all that kind of thing. I have always been an admirer of the law. And those who went to secondary school with me will tell you that there is a famous story at Osechuchi about my English teacher, Mr. Okra, who has since passed, may he rest in peace, who even when he had made it to medical school said, I think he's a stupid boy. That boy will have made an excellent lawyer. I have always admired lawyers. And so whenever I engage the judiciary and the bar and others, I do that out of veneration. I am a keen student and I learn a lot from my friends. With Ciprempe, you, Samson, from Professor Azar, from Max Logan, and a few others whose names maybe there's no time to mention. And by the way, I do the same thing in medicine. I am a fairly good doctor, but I learn a lot, even now that I'm practicing from doctors that I know. When I was in Cape Coast, Professor Deborah, Harold Aite, Uku, Dr. Anthony, now Professor Jipon, Professor Frimpong Boateng, even my sons who are in medical school. Last week, they were having a discussion on neuroanatomy and I listened in admiration. So I come to my interest in the law with a lot of veneration and love. Now to come to what the Chief Justice is trying to do, I am very troubled, not by her motives. I don't know her motives. I'm sure she means well, but by her awareness of the political situation we are. We are a few months to an election. We've had a lot of problems with our judiciary and its reputation. A lot has been done that has left a lot of bitter taste in the mouths of a lot of Ghanaians. And we can recite some of the decisions. The election petition, in which they wouldn't put Jane Mensah on the dock to talk, the shocking change of EC members with the connivance of the Chief Justice and other members of the Supreme Court, removal of Auditor General Domilovo. The perception increasingly that our judiciary, and particularly the Supreme Court, is biased, with warnings from Kandapa, who, even though an MPP member, expressed the worry of many people. Since then, other people have weighed in, former President Mahama, Mr. Opoku, who used to be Kufuor's security minister. All those people have weighed in, and 6 months to an election, all of a sudden, we hear that in a country that has 15 Supreme Court justices for a population of 33 million, compared to 330 million Americans with only 9 Supreme Court justices. We need more of them, and the Chief Justice doesn't even bother to follow the process laid down by the Constitution. I smell a rat, and I smell a rat because it will contribute to instability in the country. I think that our judiciary needs significant reform, but those reforms needed do not include just adding to the numbers of Supreme Court justices. If the work is too much, the court, or for that matter, Parliament, more appropriately, should look at the U.S. Judiciary Act of 1787 and 89, which set out the parameters of the American judiciary. The first thing, for example, is that we should cap the number of Supreme Court justices. Second, we should define the appellate process, including the picking of panels for Supreme Court cases. We should bring more transparency. And by the way, our Parliament can do a lot of these things that have the Constitution is silent on, and it will bring a lot of stability to our judicial process. I am very worried about the reputation of our judiciary and where we are leading it, particularly in the teeth of an election that is only a few months down the line.
Right, so you just raised the comparison with the Supreme Court of the United States of America, which caps its judges to the apex court at 9. Now, there is a factor you will be urged to consider and see if the comparison is a good one. In the US, you have a federal system of government that is practiced. Each of the 50 states has a Supreme Court, with the exception of Oklahoma and Texas. These have the 2 Supreme Courts, one for civil and the other for criminal cases. So if you check properly, the total number of state Supreme Court judges throughout the United States of America is 344. What do you say to that? No,
what I say to that is that
and again, as you try to advocate, their jurisdiction is narrow. The Supreme Court of Ghana's jurisdiction is wide. I was trying to calculate with a friend of mine, Dennis J. Jumo, of Dennis Law, and we were counting as to about 9 different jurisdictions. Some people have counted 7, some have counted 8 jurisdictions, but in the pure sense, about 9 different jurisdictions. Elsewhere, they have just the appellate jurisdiction, and even that you have to come by leave. That means that not everything goes to the Supreme Court. Like in South Africa, they've also capped it, I think at 11 or so, but they have a constitutional court. And then they have the Supreme Court constitutional, they have the other one for appellate jurisdiction. So what will you say about that? In terms of the numbers, that was my first question.
Sure. There's an interesting question, but if you study the evolution of the American judicial system, it was not always like this. From the Judiciary Act of 1787 to be the Supreme Court to rise circuit, in which, apart from deciding Supreme Court cases, they served as judges who rode around deciding cases. So the system has evolved. And eventually, part of why their jurisdiction and their work load has become manageable is what you alluded to, granting certiorari. Granting cert means the Supreme Court doesn't have to take every case. For example, you need to obtain cert to have 4 of the 9 Supreme Court judges agree to hear a case. So every year they hear approximately about 70 cases that they think portray conflict from the appellate courts, or questions of original jurisdiction, things that are important in law. For example, this year they talked about the Chevron. Having said all that, I just say all this to say that there are ways that you can make our court system more efficient, and I've mentioned some of them. Clear and transparent appellate process, having timelines in the decision of cases, granting certiorari so that the court doesn't have to take all cases. So there are ways of dealing around that, but I take your point that there has to be some refinement. But having said that,
and you raise an important point that they sit at the beginning of the year to determine the number of cases they will do, and you say they will take 70 cases in all, for example. What will you say if you heard that our judiciary, our Supreme Court, in these years, in 2018 and the 2019 year, they were saddled with 761 cases. In the 2019-2020 year, they were saddled with 896 cases. In the 2020-2021 year, they had 906 cases to deal with. 2021-2022, 799, and then the very 2022 and this last year, 939. And in all these, they managed, out of the 761, they were able to conclude 559. Out of the 869, they managed to conclude 653. Out of the 906, they did 694. Out of the 799, they did 385. And then finally, out of the 993, they did 344 cases. And in all these situations, doing with less than 15 judges. In some situations, 12 judges. Only at one instance, they had 18 justices, which quickly reduced to 16 justices.
Samson, efficiency. First, if you look at prioritization, for example, regardless of whatever caseload you have, the Domilovo case should have been heard quicker. And I think the delay was not because of workload. It was because of judicial politics and the fact that there was an audit of the Supreme Court that had bad findings they didn't like. Secondly, the US Supreme Court in Bush versus Gore decided that between the month between, say, December 7th and what do they call it, January 5th, when they had to go and do the ballot counting, they had decided it in a month. Look at how long it took us to decide the two presidential election cases. They went on interminably. So part of it is inefficiency. We can make these things more effective. If the US can decide a presidential case in 2 weeks and Kenya can do that in relatively short term, I don't understand why we can take months and almost get into a year. That is inefficiency. So the other reforms would obviously speed up. And then the other things is also that we should allow more of those cases to be determined by courts that are lower than the Supreme Court. So having said that, yes, I get all the case laws and all that kind of thing. I'm talking about intent. And when I'm talking about intent, I'm also talking about reputation. That, for example, when you look at the US Supreme Court, their reputation has changed. It's been low and up depending upon the nature of the cases they decide. You know, when you look, for example, at Dred Scott, you look at Plessy versus Ferguson, they were very badly decided cases. Then when you come to more good things like Brown versus Board of Education and others, then their reputation improves. So I am saying that it is an unfortunate time for the Supreme Court to make a case for more help because their reputation is getting down and the public is not supportive, even if some of the case they are making is valid. And part of it is from self-inflicted wounds. I think that it is very difficult, regardless of her motives, for anybody to look at what the Chief Justice is deciding to do 6 months to an election in the context of the warnings by Kandapai and John Mahama and not think that this is a blatant attempt to pack the court.
Okay. And I mean, listening to you and lawyers listening to you, they will endorse the facts that you narrated earlier about what your teacher said you should have been doing, because some of the cases that you know, it's only law students who are familiar with them. The Kofi, so I think Dr. Kennedy, first to you with this question about efficiency. We understand the conventional average that you have on the Supreme Court has been 15. In fact, in 2016, when the Ghana Bar Association took a suit to the Supreme Court, challenging how the president had gone about an appointment of judges, I think that was Sporman and Apau, there were issues. The Supreme Court in that decision actually has said that the court had never exceeded 14. I suppose that meant without the CJ. By the architecture of our Constitution, there are supposed to be 9 justices, CJ inclusive, a maximum of 10. But the court can do its business with 5, it can do with 7. There have been circumstances where there's a need to empanel 9. What do you say when you hear this? That conventional average of 15, only 2 panels of 5 and 7 justices or 9 justices can be constituted. This tends to exhaust the entire number of justices of the Supreme Court on a sitting day. So you have had the challenge of sometimes where you have recusal of justices. Maybe a judge has been involved in a matter before, so he comes to the Supreme Court. The judge was in the Court of Appeal and deal with the matter in a certain way, and then they have to recuse themselves. And the number continues to go down. And then there is a frequent situation where some of the judges, because they would have, like I just mentioned, dealt with these matters, they have to recuse themselves. And then also you have the ripple effects of the disruption of what we call pre-sitting conferences. The CJ has to constantly be reconstituting the panels because they are not getting the sufficient numbers to do what they have to do. So don't you think that it may be necessary for efficiency to have good numbers, to have at least 20, which is where, if these 5 are approved, we will get to. They will add to the 15 to make 20. If they add to that, then it means you can have at least 3 separate panels at any given time so they can deal with the cases. What do you say?
No, I don't. I'm unimpressed by that. Let me tell you why. The Chief Justice has sometimes moved judges around when cases have been heard and they are on the verge of delivering judgments, which have led to restarting the cases almost de novo. If he was trying to promote efficiency, he wouldn't do that. An example is the Commonwealth versus Legon case, where a judgment was about to come in a week and then she just reassigned the judge. If you were trying to promote efficiency, you wouldn't do that. I also think that when you talk about the 9 judges and then the Chief Justice, it is a flaw by the Constitution. It means that nobody knows the ceiling. I think that when you don't have a ceiling to the number of judges you have, there can be a lot of judicial opportunism. And we're about to see that. For example, when we nominate these judges, like the ones you have on the table, is it because they are the best judges around? Is it because they are loyal to somebody? Is it because they are somebody's friend?
My understanding to that question is that there are judges who have been identified as those that within the fraternity, the lawyers can confirm are judges who have speed in the way they do their things.
Yeah, but justice delayed is justice denied, but is speed always the best quality of a good judge? I have also heard judges who have different opinions about this one, but I'm just saying that these things require broad consensus within the legal community as well as within the political community. Appointing judges is a political process. As they say, a judge is a lawyer who happens to know the president, and we should also not be ignorant of charges that the courts are being packed. And it is very difficult to look at this situation objectively 6 months before an election and think that there are no political motives to this attempt to introduce more
Okay.
Supreme
Please,
Court judges.
please hold on there for
I
me.
just-
Yes. Yes, conclude. I wanted to come to Rickett Hagan, and then we'll come to you finally later.
Sure. So I just think that the way this thing is being done, it lacks transparency. And as I have said repeatedly, we just don't have to focus on the Supreme Court. I think our whole system of justice needs radical reforms that will lay out clearly a time-dependent appellate process, transparent empaneling of panels, consistent panels that are not changed at the whims and caprices of the Chief Justice. I can tell you confidently there are Supreme Court judges who don't understand some of her motives for changing panels and are very unhappy.
Okay. So I wanted to bring Kofi or a lawyer in, but let me bring you in at this point. I shouldn't presume that you may not understand this thing. He just spoke about panels. If we can take it from there. And I asked the question, if improving the number from 15 to 20 is to get a situation where you can have 3 separate panels who will be there, and therefore the issue of having to change a panel member will not arise. And then he will get the efficiency he's looking for. And a group of judges who are said to be, efficient with a lot of speed as well are being appointed. Should we have a problem with that?
Thank you very much, Samson. I think, if you don't mind, I would also like to do what Doctor did and going back on NAPO issue. Just for 1 minute. Just for 1 minute, and I will, because he said something that, where we have reached in terms of the climate that we are in as a country, what we're looking for going forward is leaders who will tell us the truth and leaders who will do that with humility. When you look on NAPO and the Excellency Dr. Baumia, you get one seen to be a liar, and you get the other seen to be arrogant. And arrogance and lies are not the kind of leadership that we're looking for going forward. We're looking for leaders who will tell us the truth and do it in humility. And that is not going to come from the ticket that we are looking at the moment. Now, on the issue of, as you rightly know, we had a press conference, and it's important that I address that.
Point 11 of your press conference, you said that the President, the Chief Justice, and the Attorney General, in agreement and in furtherance of the President's grand agenda to pack the courts and annex the judiciary as an extension of the new patriotic party. That's what they are doing. And you are saying there was an emergency Judicial Council meeting which was hurriedly convened on the 24th of June, 2024, by the Chief Justice, who is also the chair of the Judicial Council. And you say, at the said meeting, the Chief Justice, who on the face of the record initiated the unsolicited request for the additional 5 justices to be appointed to the Supreme Court. You say they are in cahoots. Now you say she's taking a list that was unsolicited. I couldn't get that clearly, but I'm coming. Request for the additional 5 justices to be appointed to the Supreme Court, presented the Attorney General's letter of 21st June 2024 to make a case for the Judicial Council to the Judicial Council for these appointments. Interestingly, at that meeting, the Chief Justice remained completely silent about her own unconstitutional and self-serving request to the President. The point is that they know from what they are saying that the process was initiated by a letter from the Chief Justice. But subsequently, there was also a letter from the Attorney General agreeing with this. And then she convened a Judicial Council meeting, at which meeting she used the alleged Attorney General's letter to begin to canvass the need for these judges while she shelved her own. But the point is,
I think
your accusation is that this is a grand agenda to pack the court.
Absolutely.
Including the fact that they are going to lose power and they are looking for judges who will help them.
I mean, clearly, from the league letter and all that, suggests that due process obviously wasn't followed. The lay down procedure or process is not a chief justice sending a letter to the president with people that he is recommending to be nominated. And it is clear from what we see at the moment that the courts or the judiciary is beginning to look like a puppet of the president. And that is of much concern to a young democracy.
The judiciary is beginning to look like?
It's looked like a puppet of the president. I mean, if you look at what is happening in the courts at the moment.
The judiciary. It's a big place, so.
Okay, let's stick to the courts.
Which of them?
Very big place too.
That might, you probably say that's a big place too. But basically, the point that we are trying to make here, and it's clearly in the thing.
This is about appointment to the Supreme Court.
Yes. Is that they are parking with people who are sympathetic to the MPP. Obviously, it looks like they are going to lose the election, and they will lose the election. So they want to make sure that people are protected. And this is what we are trying to guard against. And that's what the press conference is basically about.
The question continues to be asked. When you go to the court and you win, that's fine. Once you lose, it's becoming a puppet of the president.
From what you are seeing.
And you can't point to what wrong the president has done. That in his tenure, by some call it luck, too many judges have had to retire. And he has a constitutional obligation, duty, to appoint to replace them. What has he done wrong in that?
Well, you look at the list, or you look at the appointment, and you look at people that have been basically bypassed. And you begin to ask yourself,
okay,
why has that been the case? So these are concerns, and they are not things we should brush under the carpet. Something is being orchestrated in terms of parking these courts with people who are sympathetic to the MPP. That is the fact.
Kofi, we'll come back to his point again. But Kofi, Dr. Atta Kennedy raised the point about Domelevo's suit, which took until he had left, and it's gone. How many years after? 2 years or so after he had left, he had been pushed away. For the Supreme Court to give a decision and to hold that the president's conduct was unconstitutional. I'm starting with you on that note because of the fact that you were a part of this process.
Yes.
As led by Martin Pebu, Isankoma, of course, CDD, the arrowhead in packaging the suit to the court. And you know, as a matter of fact, that the delay cannot be squarely blamed or laid at the feet of the Supreme Court, because amongst you, I'm one of you, and we discussed these things. There were delays that were occasioned by the lawyers.
Oh, on our side or on the AG side?
You know, I'm not going to say
So
it.
let's not go into the detail, but on that issue, let us make this general point. I personally think that some of the cases in the Supreme Court do not get delayed as a reason of inefficiency, but as a reason of political calculation. It falls to the Supreme Court to disabuse our minds and to consistently act in ways that make us believe that if some of these delays happen, then indeed they were unavoidable. All that being said, look, people don't realize that there are thousands of cases that go to the Supreme Court, and a few that affect people. When it goes a certain way, then they are screaming and shouting. Let us get these things clearly. The judges are the supervisors of the realm, and that's a very onerous duty, a very powerful place. But somebody has to appoint them. And when he talks about packing the court, because this president is appointing people, there's a doctrine of necessity. He has to do it. When he does it, NDC says it's packing the court. But when you do it, NDC, when you are in power, then they also come and say it's packing the court. So let's get this straight. It is utterly distasteful when politicians are involved in the judiciary. Utterly distasteful.
I started with a direct question to you in a matter that you were involved in, which has been used as an example of the delay in the court.
And I said that I think that is a matter of political calculation, but I didn't want to be ad hominem about that.
You haven't answered that question. What does that mean, political calculation?
Because
Domilovo's
case
sacked,
was delayed,
so to speak, and then you filed a suit.
Yes, and it took over a year to hear the suit.
And who was the cause?
And I'm saying that with this huge judicial system, if you want me to go and detect who was the cause, what I can tell you is this. If we were a country and the judiciary were minded to hear that case within good time, it could have happened. So the decision not to hear it was not an accident that was unavoidable. It was a decision that was taken.
In the absence of a certain rule or regulation. For example, we did election petition for 8 months.
Yes.
Then we went to refine the rules. And the rules now say within 45 days, the case will be over. So there are specific timelines and dates that has to be followed. In the absence of that, in such a case, do you still put the blame squarely on the Supreme Court that the Domilovo case delayed?
I believe the Supreme Court can do far better than it did in a Domilovo case.
But the lawyers had work to do, which they also defaulted on some occasions.
In the Supreme Court, sometimes the lawyers are instructed on this and that and that, and the cases are abridged and things move faster. So see, my submission, maybe we'll deal with some of these things. We did a full program for this. And we'll be talking about...
I get that, Kofi. I needed it to be clear that whilst you did your part, and as Martin Pebu was leading the process, we saw how he got frustrated at certain points where he was looking for the court to issue a hearing notice for the matter to come on.
The system was frustrated.
It was not coming on.
Yes.
But for the period, there were times that you could say that there was a certain laxity on the part of those pursuing the case.
I don't want to go. Look, this is the conclusion. If you ask me, I'm telling you, that case did not have to be heard after all that time. It could have been heard earlier because it was time bound. Okay. Now, all that being said, there are issues with our Supreme Court. Again, comes to your point, which we can't blame on the judges. If you ask me, I think we need a bigger Supreme Court. Why? We copy too many things and we don't understand the history and the evolution that led to those things. Why would I want a bigger Supreme Court? I think we should have 3 panels in Accra alone and at least 1 panel in Kumasi. You know, we have
a Supreme Court panel.
I'm struggling to pack everything in. So what I mean is if we have more Supreme Court justices, you can have 3 different Supreme Courts sitting. In Ghana, we have only 1 High Court. You know that.
That's right.
Various divisions.
That's right.
I don't see why we limit ourselves to even the 15 when we have this load of cases, all right? So why don't we have a situation where in Accra, okay, we have 3 Supreme Courts sitting in Kumasi 1. Why don't we have specializations in the Supreme Court? All of them are Supreme Court justices. They can be empaneled. The empaneling system should not depend on one person. There should be an algorithm for empaneling. And there should be specialists. There should be specializations. We ought to have a constitutional case panel. We ought to have
so the present approach is going to 20 justices of the Supreme Court. And you are endorsing that?
No.
Because that will give you 3 panels.
No. What I'm saying is we need to go down to first principles and do some original thinking to redesign our Supreme Court to fit our needs. Comparing to the US Supreme Court is wrong. They cap the number at 9. They take only 70 cases a year. And like you said, there's a Supreme Court in every state. They've designed a system that fits and makes sense for them. If our Supreme Court justices can cap the number of cases, indeed, if we cap the number of Supreme Court justices, then we should cap the cases. But you see, that thing we do here, where every case can go to the Supreme Court, is a plus, it's not a minus. So if we're going to keep that, then why don't we expand the Supreme Court? Why don't we have more Supreme Court panels sitting? Why don't we have specializations? Why don't we have 1 in Kumasi? So look, I'm saying 1, we need original thinking here. 2, we need to rethink the process for empaneling judges and also appointing judges. First question, what wrong has the Chief Justice done in what he's done? Everybody is complaining about it. But
exactly. So let's get to that. That's the core point.
So I'm coming there. Now, is it that she broke any law? And by the way, in this discussion, sometimes we've lost the public because...
Have you seen the letter?
I haven't seen the original letter. I've seen, all kinds of...
Okay, so the letter, the letter is the letterhead, Honorable Chief Justice, the one you are familiar with. Honorable Chief Justice of the Republic of Ghana is dated the 30th of May, 2024. And, forgive me, and she writes, it's addressed to the President, and it's headed Proposal for Appointment of 5 Judges to the Supreme Court. And Arthur Kennedy and the rest take issue with this. First is a letterhead of the Chief Justice. It begins by, I write to respectfully request that the following judges be appointed to the Supreme Court of Ghana. Remember, it's I.
Yes. And on her letterhead.
Then, yes, so
don't belabor the point.
It concludes.
Let me use the time.
concludes in her own capacity and position.
Let me use the time.
Yes.
See, so we know what has happened. I think it is not, the optics are wrong for she to be doing what she's done. But I ask myself, what law did she break? Hold on with me. See, the thing is, you have a Chief Justice. There's an appointment process where the Judicial Council advises on the advice of... Look, sometimes we make these rules and evolve conventions which essentially are an honor system. We expect people to be restrained in how they manage themselves there. We've gotten to a point where we cannot expect an honor system. So my issue is, maybe the Chief Justice shouldn't have done that. It is a bit too personal. No one person must have such a say in the appointment of judges, nor even in the empaneling. Hold on with me. So, if she hasn't broken any law, but then we realize that she can do a thing like this, which we all find distasteful and can argue against.
What do you know?
What do I know about what?
It's not an if. What do you know?
I'm struggling to find what law she's broken.
Is she permitted by law to do this? What's your answer?
No law, has to permit her to do something. She is taking some latitude.
What does the provision of the Constitution on the appointment of a judge to the Supreme Court say?
GB has a role, the Judicial Council, on the advice of the Judicial Council. Now, we have evolved some interpretations to the effect that the Judicial Council should develop the list. It is not written expressly anywhere. So I'm back to this point. We copied from here and here and here. Let us sit down, think through using first principles and decide what is the best approach for us. I think we must have a greater role for the Ghana Bar Association. Why? We work with them daily. There must be a greater role for the Judges Association.
Article 1442.
Samson,
we
don't have the time.
I need to read. We need the context. Article 1442. The other Supreme Court justices shall be appointed by the President acting on the advice of the Judicial Council.
Council, yes.
In consultation with the Council of State and with the approval of Parliament. The question people like Dr. Arthur Kennedy are asking, he says, while the CJ is the chair of the Judicial Council, her letter to the President does not mention the Judicial Council. Clearly then, this is not a communication on behalf of the Judicial Council.
Agreed.
What then was her motive? What were the criteria for those selected?
So, Samson, here's the thing. What stops the CJ as the head of the judiciary from making a suggestion to the President that, look, we are constrained over here. I run this system and I can see the issues. Here are my suggestions. Please, can you do something? What stops her in this scenario, from doing that? And then the President goes through this process. What she's done, does not stop the constitutional process from going through or being gone through. So my point is, if we don't want her to do that, let us be clear about that. But when you have a clear lacuna, as the head of the institution, somebody will say this is
you and I were in this country.
I don't like
you and I were in this country.
I don't like
when
it,
the Judicial Council, performing its obligations, generated a list for President Mahama to appoint as justices of the Supreme Court. And President Mahama picked from the list. Then the Ghana Bar Association, led by Nana Megache, who became Supreme Court judge, went to the Supreme Court and said President Mahama does not have that option to pick from the list and in fact decide to jump from maybe 1, 2 to the third or to the last person under. And the Supreme Court was unequivocal that the process must necessarily be at the initiation of the Judicial Council. Without the Judicial Council's advice on a list of people to be appointed, the president cannot be making appointments.
So something I'm still saying, I don't like this. But when the CJ writes to the president, it is not an initiation of the process. That can be argued. She's saying, look, we have a problem here. Can you consider these people? The president can totally ignore it. Or now the president or whoever has to, the Judicial Council now. If you ask me, I'd have said the CJ should have worked through the Judicial Council and gotten the process to work. But look, in this country, formally and informally, all kinds of whispers happen. People make suggestions, people make recommendations, horse trading happens in the back. I'm back to my point. My point is, we need to rethink this whole process because it is more or less an honor system. And when you find somebody who will not...
Dr. Kennedy, let's hear you. He has a quick rebuttal. Yes.
Kofi,
Yes.
Why are you making life complicated for yourself? Even I can understand 144.2, the Judicial Council. Why couldn't the CJ just call a meeting and say, guys, we have a problem, let's see how we can solve? If the CJ can follow these simple rules, particularly given the Supreme Court ruling we just referred to, is our judicial system in safe hands?
Doc, I actually agree with you that this was not right. But I keep asking the question, is there anything that stops her from doing that? And I'm saying there's nothing that stops her from doing that.
Okay.
Then what we should do is prevent this in future. But this was a suggestion.
Okay.
The Judicial Council can now...
Dr. Kennedy says the timing is wrong.
I agree.
You do?
Absolutely.
That because we have 6 months to elections, the needs of the Supreme Court should not be met.
No. You see, again, that is why it's not easy to run a country. Look, the Supreme Court clearly has needs. My problem is you don't wait 6 months to an election to do a thing like this.
If I told
why didn't
you,
we do this?
If I told
why
you,
didn't you use the proper?
If I told you
process?
that this process started in February, right? Started in February, the Ghana Bar Association's input was sought. They did not disagree. The Attorney General's input was sought. He did not disagree. And there was a proper brief of research work of many pages indicating the circumstances that the judges find themselves vis-a-vis the load that they are saddled with. And I shared some of the statistics with you. At a point, there were 12. At a point, there were 14. And even in that number, there will be circumstances, some will have to recuse themselves. There will be circumstances, some will just not be available because of certain situations. And there will be the need to reconstitute them. And people are not happy with the reconstitution, but they don't get to know why the panel is being reconstituted. So if you got to know that the panel, this process started in February, will you still say it's too late in the day?
I will say you need to appreciate the dynamics. You don't work in a vacuum. So you should have done it earlier and quicker. Indeed, I'm not defending the CJ. What I'm saying is that I think she has a certain right as the head of the Judiciary to generate this list and make a suggestion. But I suggest that she doesn't do it because of these things. Now, if you were starting all that time, what was the Judicial Council doing? Why couldn't you work the system to get the process to work out?
So hold on, let me see if Ejapa Mensah will agree with you. On this very substantive point, in the face of Article 144, which is very clear that this must be generated by the Judicial Council, you still say the CJ can do this so motu. And I'm not suggesting that I know enough that the CJ generated this so motu. Yes, Ejapa Mensah, what do you say? Do you agree with Kofi on that score?
I don't. Because, you see, Samson, if you read the provision, say other Supreme Court justices shall be appointed by the president acting on the advice of the Judicial Council. So is it a suggestion that the president himself cannot generate a list for the Judicial Council's consideration and advice?
He's agreeing with
Is
me,
it
actually.
that the Chief Justice cannot generate a list for the President to submit to the Judicial Council for consideration and advice? I do not think so. Okay. Now, if the Judicial Council then makes its advice known, then the decision that you mentioned in the case against Puaman and Co.
Yes.
That list cannot be tinkered by the President, then arises. Otherwise, I really don't see the big deal about all this duha. In any event,
let's be clear. Let's be clear. The Supreme Court didn't say that the President cannot tinker with the list. Advice remains advice. If advice were compulsory, then they say it will not be advice. So, so the Supreme Court, what the Supreme Court was clear about is that, and it said it in these terms. What is clear is that all the authorities involved in the process for appointment of Supreme Court justices are bound in the exercise of their various powers by Articles 1284 and 926A and B of the Constitution. And to the point that they must do whatever they have to do, but at the end, it must follow from being recommendations of the Judicial Council.
Yes. So I'm saying that the fact that the Chief Justice has written doesn't mean that the processes that is outlined in Article 1442 cannot be complied with.
All right.
In any event, I hear talk about packing the court and all sorts of talk. Those are the politics, which is fine.
Entirely distasteful.
Because if there was some ill motive, why the Chief Justice couldn't have gone to sit in the President's office to have a discussion with him, which he have written a letter that is in the public domain today. So what's the issue?
Do you share in the view of Arthur Kennedy? Do you share in the view of Arthur Kennedy that the letter emanating from the CJ and the context of it suggests it is the CJ's work and not the Judicial Council's work? You don't have any issue with that?
I'm saying that the suggestion from the Chief Justice is not conclusive of work having been done by anybody. If the President is minded to make a recommendation to the Judicial Council for them to consider, that process that is outlined in 1442 would be complied with. Not so. But you see, unfortunately,
let me understand you. Let me understand you. You are saying that when the CJ writes and says, "I'm proposing these people for your appointment,"
yes,
and then the conclusion says that they have distinguished themselves and so on. So this is the names I have submitted. You are saying that when the CJ is submitting, she is allowed in law to submit to the President, and that not having written for and on behalf of the Judicial Council is not an issue. The heading is proposal for appointment.
She's making a proposal.
Right.
Now, that proposal will have to have the input of not only the Judicial Council, but the Council of State.
Okay.
It is pursuant to the advice of the Judicial Council and the Council of State that the President can actually go ahead and submit the names of these people to Parliament through the Speaker for consideration.
So your explanation is that this letter is part of the commencement processes, which will ultimately end up at the Judicial Council.
Thompson, it's not obvious. As far as my reading goes, it's so obvious that controversy that is generating is neither here nor there.
Mm-hmm.
But then again, of course, for the NDC folks, I do not have any issues with them, because that's exactly what I would expect them to do. Play the politics. But I haven't read fully Dr. Arthur Kennedy's piece. I've read only excerpts.
So
where he
yeah, so help me. Is it your expectation that Mesa, hold on. Is it your expectation that this letter is what the CJ wants to deal with, proposals? Then there will be another one from GBA. Then there will be another one from the Attorney General to coincide to go to the Judicial Council. Is that your expectation?
You provided some background.
Yeah.
I'm not privy to that. But my expectation would be that if the president is minded to look at the recommendation of the Chief Justice, he would then submit it to the Council, Judicial Council, which is composed of the Chief Justice, Attorney General, and representatives from the Judiciary, the Bar Association, and all that. They would then consider the request to determine whether indeed these people merit being considered for appointment.
In fact, the Attorney General, the Ghana Bar Association have all made their inputs on the list.
Already?
Yes.
But it would be good for us to see those recommendations. But I'm saying that to the extent that the law is clear on who makes the recommendation for or advises the president for appointment, this process does not in any way, if you like, truncate that constitutional provision in Article 1442 at all.
Okay.
But I'm going to the
You do not also disagree with the timing of it?
I think it's frozen.
Did I lose you? The timing, okay.
My quick point, see,
I need to move on.
I know. See, what starts the process? So like you said, this is a suggestion by the CG. Other people could have made suggestions. In the US, they have the Federalist Council. They actually made the suggestions to the president. Then the process starts. So it is the president can ignore this letter and any other. But the president cannot ignore the suggestion or the recommendation coming from the judicial.
Does it matter that this president, you would have a judiciary, a Supreme Court that is constituted by persons, all of whom were appointed by this president?
It does. You see, the doctrine of necessity, which you and I understand, we don't have time to explain, makes that his prerogative. You see, in the US today, somebody had the opportunity to appoint 3 justices and has changed the course of history, settled law over 50 years. So the doctrine of this, like I said, it is entirely...
No, the question that is being raised is that, is this right?
So I'm saying, right or wrong, I don't like it. The timing is wrong and all that. So they who have the power must be minded. But if it falls to you, in fact, I don't like the long examples, but when President Trump came in, he appointed hundreds of judges. And they were saying that Obama could have appointed all those judges. He didn't do it. And so he did it. Now, people are complaining about it, but it fell to him to do it. When it falls to you, you have to consider so many things. Obama didn't do it because he thought, oh, why should I appoint all these things? That was an honest system. He didn't use the authority he had because he was thinking about broader things. The next person did not think the way he did.
Okay.
Which is why I'm saying, let us...
No, but I'm saying those are completely different situations.
You're asking whether it's right
they
for this
serve
president
for
to
life.
appoint so much.
US, they serve for life. And there are some there, and then someone comes to add on. Here, the question politically and sort of morally being asked is that you have a president who came into office and not by his fault. Many are retiring. So he has to replace them.
Necessity.
So you are at a point where the peak of the number, the unconventional ceiling of 15 are all his appointees. And then you want to add on to make 20. And it's 6 months to elections. And you say it's okay to have 5 more by the same person. That's the question people are asking.
And I disagree with the timing and how it looks, which is why I'm saying, even though it doesn't look right, there is no legal impediment. And where there's a necessity, it has to be done. So let us evolve, find a way to innovate a system that we can all live with, because we are risking this democracy with these things.
Okay. We lost him there. You want to make we want to move on to the next issues, but this is an issue that will clearly engage our attention in the coming week, because it is an issue that is still being debated. But we have seen a case that is being made that the numbers there is a necessity for it, but it's a timing that people are seeking to question. As to whether there was a presentation at the Judicial Council and there was an objection by the Council, we do not have those facts. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And my guest, Andrew Ejapa Mensah, MP Secondee and Minister of Tourism, Arts and Culture. Kweku George Ricketts Hagan, MP Cape Coast South and former Deputy Minister for Finance. Kofi Bentil is lawyer and Senior Vice President, Imani Africa. Dr. Arthur Kobina Kennedy is physician, political activist, and Chair, MPP Communications Committee 2008 campaign. So there's a warning that important people are giving, or significant people are giving in the country at this moment. Let's listen to Francis Spoku and Kwesi Enin, and then Afenyo Marking, and come back to the table.